Welcome, and thank you all for joining us for another Justia webinar. My name is Nina, and I'll be the moderator for today. Before we begin, I wanted to remind you all that today's presentation is eligible for CLE credit. Please note that to receive CLE credit, you must be upgraded to Justia Connect Pro, as well as stay for the entire webinar, as today's presentation focuses on reviewing the 2023-2024 Supreme Court of the United States term. We wanted to highlight one of the best tools to stay caught up on the newest case law results and updates, the free Justia Daily Opinion Summaries. One of the benefits that you get just by being a Justia Connect Pro member. You can pick the jurisdictions and practice areas that you're interested in, and we'll send you case summaries right to your inbox. If this interests you, please feel free to visit us at newsletters, that's newsletters plural, .justia.com. You can sign up there for free, and you'll always be in the loop for what's happening in the legal world. Now, to kick things off, I want to go ahead and introduce our speakers, Vikram Amar and Michael Dorf. Vikram Amar is a distinguished professor of law at UC Davis and was previously the dean of and a professor of law at the University of Illinois College of Law from 2015 to 2023. Amar has also taught at Berkeley School of Law, Hastings College of Law, and UCLA School of Law. Amar is one of the most eminent and frequently cited authorities on constitutional law, federal courts, and civil procedure. He has written several books and more than 60 articles in leading law reviews. He is a co-author of the upcoming revised multi-volume treatise on constitutional law, pioneered by Ron Rotunda and John Nowak. Michael C. Dorf teaches constitutional law, federal courts, and related subjects at Cornell Law School. He has authored or co-authored 6 books and over 100 scholarly articles and essays for law journals and peer-reviewed science and social science journals. He also writes a bi-weekly column for Verdict and publishes a popular blog, Dorf on Law, which you can visit at dorfonlaw.org. He also received his undergraduate and his law degrees from Harvard. The webinar presentation that you're about to watch will be approximately 1 hour, and once Mike and Vic have wrapped up their discussion, they will be taking audience questions. So if you have any questions that come up that you'd like them to address at the end of the presentation, please feel free to submit them through that Q&A button in the control panel at the bottom of your screen. Now, without further ado, here are Vikram and Michael to discuss breaking down the bench, key rulings from the 2023-2024 Supreme Court term.
Wonderful. Thank you, Nina, for that introduction. Thank you for hosting this webinar, and I want to thank the audience members as well. Mike and I look forward to talking with each other and talking with you all. And I guess we thought we'd start by each offering a little bit of an overview of the term before we descend into particular cases. From my point of view, and Mike might differ a little bit, this has been a kind of an interesting term in that there were a lot of incendiary cases on the docket, perhaps more than one would expect in an election year. But many of them were cases the court really didn't have a choice not to hear. So cases involving the election itself or President or candidate Trump were cases that had to be decided now, if at all. There were several other important cases that were kind of imposed upon the Supreme Court by the actions of lower courts. So lower courts had struck down various federal actions and laws, and U.S. Supreme Court had no choice but then to take those cases up once the United States sought review. My sense of the overall term, and there were fewer than 60 cases that were decided, is that in many of the incendiary cases, the court did a pretty good job of showing judgment and discretion, but that is probably not going to be the takeaway from the term, in part because the 2 biggest cases, arguably, the Trump versus Anderson case from Colorado involving access to the Colorado ballot and the Trump v. United States immunity case, those were both terribly decided rulings that I think are going to be criticized by many scholars for many, many years unless they are corrected. And so given the anchoring effect of that Trump v. Colorado case, the Anderson case, and then the recency effect of the immunity case, this term is going to be viewed as one where the court was more partisan and more aggressive than I think might actually be the case if you look at all the other cases in the middle involving gun rights and taxation of the federal government and abortion and the Consumer Finance Protection Bureau and whether it continues to operate and the like. So again, I think in the middle of these bookends, the court really did do a good job of not deciding cases in aggressive or wrong-headed fashion, but that might be kind of swamped by the two Trump cases that the term might be known for. Mike, I'll turn it over to you.
So let me add my thanks to those of Vic and say how delighted I am to be back here with Vic at the end of another tumultuous Supreme Court term. As I think often happens, Vic and I are not going to disagree about a whole lot, although we might try to highlight different nuances. So I broadly agree. In fact, my sort of Supreme Court wrap-up column for the term was titled "The Supreme Court Term That Was and Wasn't." And the was part, I think, is obvious, right? The decisions involving Trump, the cases that Vic will talk about a little bit, reining in the administrative state, the big gun control case that I'll talk about. Those are big cases. Those are the cases that were, as it were. Another one is the Purdue Pharma case, which we might not have time to talk about, but interestingly divided the court not on ideological grounds. And so, yeah, in those cases, the Supreme Court looked, very partisan, with the exception of the case I just mentioned, and looked like it was sort of pursuing an ideological agenda, even as in other cases, they seem to be going out of their way to decide as little as possible. In the late 1990s, there was a popular idea of judicial minimalism. Cass Sunstein wrote a very influential Harvard Law Review foreword talking about the Supreme Court and minimalism, trying to decide as few things as possible. And you can look at some of the cases that the court disposed of without merits decisions, in particular, two cases involving abortion that I'll speak about a little bit later, a challenge to the Biden administration's social media policy, in which the court used procedural grounds basically to get rid of cases and as a way of not having to decide the substance of issues that were teed up and foisted upon them really by the Fifth Circuit in most of the respects, which is, even more conservative than the U.S. Supreme Court. So that I think is the sort of background, but the main signal is, of course, this, the seeming very partisan. Let me just add one more word by way of overview. One sort of, I think, theme that emerges, although is not dominant because of the lineup and the other matters, is the beginning of the emergence of Justice Amy Coney Barrett to have a distinctive voice that I would say is a little bit more scholarly and more principled than some of her conservative colleagues. It hasn't made a difference yet, but I could see that down the line it might. And if we have some time, I'll give examples of that later. But why don't we dive into the first major case now, and I'll turn it back over to Vic for that.
Thanks, Mike. Before we do that, I want to amplify one thing you kind of adverted to there, and that is the extent to which the Fifth Circuit Court of Appeals in particular, which of course governs Texas and Louisiana, really got slapped down by the Supreme Court in many, many cases, and really forced the Supreme Court to take up some of these contentious issues that it otherwise would not have. So if you look at the mifepristone case involving the abortion pill, if you look at the Rahimi gun control case, if you look at Murphy versus Missouri involving the federal government's ability to speak to social media platforms to get them to act responsibly, if you look at the Consumer Finance Protection Bureau case, I'll speak about a little bit later, and if you look at the Net Choice case that created a split with the 11th Circuit over the extent to which states can force social media platforms to take all comers, even if they want to curate the speakers as part of their own speech on behalf of the platforms. In all of those cases, the Fifth Circuit took a beating. And it wasn't that long ago that the court that I clerked for before clerking at the Supreme Court, and Mike, I believe you clerked for the same court, the Ninth Circuit out in California. I clerked for one judge right across the hall from the judge that Mike clerked for, and the Ninth Circuit was kind of the unfavored child at that time, and it was getting reversed, and not just reversed consistently. Because most cases reverse the lower court. That's the nature of it. But reversed lopsidedly, reversed 8-1, 9-0, as the Fifth Circuit was often reversed this term. So with that, let me dive into Trump versus Anderson. That was the case in which Colorado had excluded Donald Trump from being considered as a candidate for the primary ballot, and on the ground that he engaged in insurrection or rebellion, which disqualifies him from federal office under Section 3 of the 14th Amendment. Now, the U.S. Supreme Court reversed the ruling of the Colorado Supreme Court. And let me give you the good news first, the silver linings. First, the U.S. Supreme Court did not address or call into question whether President Trump's conduct could, in fact, constitute rebellion or insurrection within the meaning of the 14th Amendment. Nor did the court take the bait on these, I think, quite silly arguments made by some scholars that presidents aren't covered under Section 3, either in the oath that they take or the office for which they are qualified down the road. So those two issues, which I thought were real kind of red herring non-starters, the court didn't say anything that troubled me. But instead, the court said that states can't enforce Section 3 until and unless Congress acts. Congress has exclusive power to implement this prohibition on people who took an oath to support the Constitution and then violated it by engaging in insurrection or rebellion from serving in future federal office holding. And I guess what troubles me about that ruling is that it was kind of made up. There was not a lot of history the court relied. This was not an originalist opinion by any means. And like the Trump immunity case that you'll talk about a little later, Mike, the court teased out a value, in this case, uniformity in the administration of a federal election. In the immunity case, it was the value was freeing a president up to not be too worried about post-presidential liability. But here, the court just came up with this value of uniformity in presidential elections and asked, wouldn't it be problematic for some states to exclude some candidates and other states not to? As John Roberts, who's a brilliant lawyer, asked quite unimpressively at oral argument, if we allowed that, then God forbid, maybe the election would come down to just a few states, as if that's not what the Electoral College is in recent centuries, if not for longer. So I think there are a lot of questions the court needed to answer that it didn't. For example, why are states allowed to enforce Section 1 of the 14th Amendment, the equal protection and due process clauses, but not Section 3 when Congress didn't say anything about treating those differently? And more importantly, how on earth do you square a vision of uniform presidential elections with the Electoral College that we have, which is the epitome of disuniformity? For example, Robert Kennedy Jr. is going to be on the ballot in some, but not all states. Ralph Nader was on the ballot in Florida, but not in a handful of other states. And we saw that disuniformity basically decided the 2000 election between Bush and Gore. So the idea that uniformity is what drives this outcome is really, I think, hard to stomach from a court that cares at all about original meaning and structure. And in that regard, I'll make just one other observation, or two other observations, and then throw it to you, Mike. One is that even if you say that states can't enforce Section 3 because only Congress can do that, what's to stop a state from prohibiting somebody who engaged in the same conduct that Donald Trump did from competing for that state's electors as a matter of state law? So let's say California says, as a matter of state law, we're going to have this beauty contest for electors, but no one can compete in that contest who has engaged in the kinds of things that Trump did. That's a totally adequate and independent state law ground, then we know from Article 2's electors clause, each state gets to appoint electors in whatever way it wants. And I can't imagine there'd be a good basis for the U.S. Supreme Court to step in there. And yet that would be kind of, again, another example of the disuniformity that characterizes the Electoral College. Last thing I'll say about this case is, like the immunity case that you'll talk about, Mike, this one was done in a hurried basis. There was expedited briefing and argument. They had to get the case decided before the Colorado primary voting process began. People might remember there was some metadata in the originally produced PDFs that suggested that there were last-minute changes. Justice Sotomayor's concurrence might have been a dissent in part at some point. And I think the courts deciding these huge cases like this one and the Trump versus United States immunity case on a tight timeline where they either need to get it out because of the election coming up, or they want to get it out because they want to get out of town and go on their European junkets, as in the case of the immunity ruling, I think it's not serving the court well at all, this kind of pressured decision-making.
So let me start there. And I think I have maybe found one area of disagreement just at the very end there, although I agreed with everything else that Vic said, which is it is undoubtedly true that decisions that are rushed are of lower quality. I thought that when it was decided, Bush v. Gore was not only poorly reasoned, which I continue to think, but that there was no plausible argument for the result. And later, Henry Monahan, professor at Columbia, wrote a pretty good article that I think made a better case for the result, certainly than anything you saw from any of the opinions, because he took a year to write that, whereas the justices had a little over a week. I think that's true here too. But of course, one of the big problems with what the court did in the immunity case was that they didn't grant certiorari before judgment, and then they took their time, relatively speaking. Yes, it was the last case argued for the term, end of April. They got the case out end of June. That's only 2 months. But if you think about historical comparisons, the Nixon tapes case was decided in basically a week. There have been occasions when the court has had to act with alacrity, and I would rather that they exercise good judgment and move quickly where they need to, and maybe not write the most well-reasoned opinions, and maybe even have a practice where you can go back and sort of edit the opinion thereafter. So that might be something you could do, but that's with respect to timing. I'd say one other thing about the Colorado case that I found pretty astounding, and that is the textual argument against the majority's position is very, very strong, because Section 3 of the 14th Amendment has its own little override clause. It says that Congress, by a 2/3 vote of each house, can lift the disqualification that applies to someone who is engaged in insurrection or rebellion. And the court doesn't rely on that. Instead, it relies on Section 5, which is the general enforcement provision for the rest of the 14th Amendment. But if you just think about the logic of Congress being able to remove a disqualification, it strongly implies that in the absence of congressional action, the default is disqualification. Now, to be sure, you need some body, whether it's a court or a Secretary of State subject to judicial review, to actually decide whether any particular individual has engaged in insurrection or rebellion. But the notion that Congress has to first enact a statute for that to operate seems to me flatly incompatible with simply the text of Section 3. And it's notable that the 3 Democratic appointees on the court who joined in the bottom line did not join on that specific point. They did not think that the court should have said anything about the mechanism by which the federal government should be applying Section 3. So that's all I have to say about that case. Vic, you want to have the last word in the case?
Yeah, just really quickly. You made the point that all 9 justices did join in the bottom line. So unlike the immunity case, this was not partisan as to result. There were some differences in reasoning. But what surprised me most about this case is that all 9 justices kind of goofed as to what the right result was, and that the liberals went along with this seemingly for the sake of some kind of institutional unity. And I don't disagree with you that the court does need to act fast sometimes. But in both cases, maybe taking just a few more days might have smoothed over some of the rough spots. But I hear what you say about the need to act, especially in some of these cases that arise quite quickly.
Okay, so now I'm going to talk about the cases that handed down the last day of the term, or one of the cases handed down the last day of the term, the one that got the most attention, Trump versus United States. So of the 4 prosecutions of former President Trump, this is arguably the most serious in that it is the prosecution for his actions leading up to and on January 6th, focusing primarily on the false electors scheme. Listeners will recall that under the guidance of John Eastman and Ken Chesbrough and some other lawyers, the Trump team came up with the idea that they would stand up a collection of electors in each of the states that they lost that they thought they could make a challenge to. And the most innocent explanation for this that has been offered is, well, this was just in case the courts ruled that the election had been tainted. But it's quite clear from what we've learned that that wasn't all of it, that the real goal here was to get Congress in its joint session and Vice President Mike Pence to discount the actual certified electoral votes and substitute these fake electors' votes, or at least say there was enough of a contest to prevent certification of the outcome and then maybe send it back to the states, which was something they were advocating for those 2 weeks between January 6th and inauguration on January 20th. This, as we know, ultimately didn't work. Vice President Pence didn't go along with it. We then had the insurrection, and this is the indictment that comes out of that. And one of the grounds that Trump's legal team advanced for throwing out the indictment was the claim that a former president is immune to prosecution for official acts unless that president has previously been impeached and removed. And that's because the impeachment clause says that persons who are impeached and removed shall not be subject to any criminal penalty for that, but can be subject independently to criminal prosecution. And so the Trump lawyers were effectively conceding that, yes, if Trump or a future president were impeached and removed, then, of course, they could be tried because that's what the impeachment clause takes for granted. But because that didn't happen here, the default was that he had immunity for his official acts, or as they put it, in the outer perimeter of his official duties. Most scholars, I think Vic and I fall into the category of most scholars here, thought that this was a very weak claim. And in fact, there was a lot of speculation that they decided the Colorado case the way they did, and they were going to split the baby so that Trump would be on the ballot, but subject to being convicted if that's what happened during this case or any of the other criminal cases. It was thus something of a shock to me that not only did Trump win the immunity case on partisan divide, but that he actually got more than he asked for. That is to say, the rule that Chief Justice John Roberts announces in his majority opinion has 3 parts. Part 1 is the president is absolutely immune for core executive functions. Now, there isn't exactly a definition of core executive functions, but there are some examples. The pardon power is given as one of the examples. And if you just think about that, you think, well, does that mean the president can't be convicted, or former president can't be tried and convicted for taking a bribe in exchange for a pardon? A question raised by the dissenters and even by Justice Barrett in a concurrence. And the majority has a footnote 3, that purports to respond to this in a way that I frankly don't understand. I've read it about 100 times now, and it doesn't make any sense to me. So there's these core executive functions, and for the core executive functions, completely off base, commander-in-chief. That suggests, for example, that this hypothetical that got a lot of attention during the Court of Appeals oral argument of the president ordering SEAL Team 6 to assassinate a political rival would lead to immunity under the majority's approach, because being commander-in-chief and giving commands to the military is a core executive function. And the majority's response is to say, well, we don't need to deal with far-fetched hypotheticals. And it's somewhat amazing to me that they call that a far-fetched hypothetical in circumstances in which the actual case involves allegations of a sitting president plotting to avoid leaving office and then encouraging a mob. So that's the first category. Second category is other official conduct. And there the court says that the president is presumptively immune. But the burden is on the government to overcome that presumption. And as is evident from the way that the court talks about it, the government has to show that there's basically no chance that this is going to interfere with the president's conduct of his functions. That means effectively the president has absolute immunity for his official acts. And that, as I say, that's more than what Trump's lawyers were asking, because that's not even subject to unless he's impeached and removed. Finally, the court adds this very strange idea that the government, in the prosecution of a former president for unofficial acts, cannot introduce official acts as evidence of the violation of the law that was done as an unofficial act. And that is quite extraordinary. As Justice Sotomayor points out in dissent, that's not the way evidence law normally works. Typically, if somebody, I'll give you an example. These are real cases. Somebody is on trial for committing a crime while in prison, and the government introduces evidence that they are in a white supremacist prison gang. Well, you couldn't charge them directly for being a member of a white supremacist prison gang, because repugnant as it is, that's a matter of freedom of association and free expression. But you could certainly use it as evidence if it's relevant to their motive, opportunity, and so forth. And so this is an extraordinary rule, and it has already been invoked by Trump's lawyers as a basis for reversing the conviction in the New York State hush money case, because Hope Hicks, who was working within the administration, was one of the witnesses that testified. And the argument of the Trump team is, well, she was testifying with respect to official acts. That's official act evidence, can't be used. So I could say a whole lot more, but I want us to be able to talk about other things, and I want to give Vic a chance to weigh in on this case.
Thanks, Mike. I found this case absolutely pathetic in its reasoning, in its outcome. Let me just add a few criticisms to those effective ones that you've already leveled. First of all, nobody at the founding said anything about this. You would have expected that if the president were going to enjoy some immunity from otherwise criminal conduct, someone would have said something other than that we are a government of laws, not men. And yet the Federalist, the impeachment provision itself that subjects people who engage in treason and bribery to subsequent criminal prosecution, silence. And yet, as the court sometimes reminds, elephants don't hide in mouse holes. Here, the silence at the founding is deafening. Beyond all the criticisms you just made, I still have no idea what official conduct versus unofficial conduct is. You pointed out footnote 3, where the majority seems to acknowledge that a president could be prosecuted for taking a bribe. But that led me to believe, okay, if you take a bribe to issue a pardon, since the bribe is in connection with this core executive power, why isn't that covered by the absolute immunity? And if the answer is, well, anyone can take a bribe, but only a president can actually issue a pardon, that doesn't quite work, because a bribe is more than accepting money. Bribe is accepting money in exchange for a promise, and only a president could make a promise to issue a pardon, because no one else has the power to deliver on that. So in addition to the weird evidentiary where you can prosecute for bribery, but you can't really prove it, which is bizarre, and as Barrett pointed that out in her concurrence, I have no idea where the line between unofficial and official conduct is, which is very uncharacteristic of John Roberts. Say what you will about him, He's usually a very clear lawyer, a very clear writer. But this case, and again, maybe because of the press of time and maybe for other reasons, is just filled with kind of nonsense combinations. So, for example, Justice Barrett concurs, and she writes separately, but she seems to join parts of the majority opinion that she disagrees with in her separate writing. I mean, where does that come from? Let me give you one other example of the kind of incoherence of it. You pointed out rightly that in this second category of non-core but official conduct, the president is presumptively immune. And the one example the majority gives for that are Trump's conversations with Vice President Pence over whether to certify. The court says that's clearly official conduct because when the two of them are discussing their official duties, that's job-related stuff. And then the test the court says is, as you rightly intimated, the government has to prove that imposition of criminal liability couldn't have any burden on the discharge of the official duty. Well, you've already said that these conversations were part of an official duty. And how on earth could the imposition of criminal liability impose no burden on that? So this second category is a no set to me. I analytically, because Roberts uses the word any burden, he doesn't say undue burden. He doesn't say excessive burden. He doesn't say unwarranted burden. He says the criminal prosecution can't impose any burden on the discharge of official powers. What's left? How could that second category have any meaning? So I really think the case was very hurried. Here's my silver lining takeaway for this. Because it's so unclear and murky and incoherent, the court is going to have another bite at the apple if and when this ever comes back after the lower court vets this test and applies all of it to the indictment. And maybe the court will kind of see that it needs to rein in some of its broad rhetoric and fix the problem a little bit. But that may be wishful thinking on my part. You want to say anything else before we move to another case?
Yeah, just two last things. So, Vic, your discussion of the very poor use of the founding and the original understanding calls to mind to me the fact that the core of this case is based on a case from the Nixon administration called Nixon against Fitzgerald, in which the court said that the president has absolute immunity against civil damages lawsuits for his official conduct. And the court basically says, well, if the president has absolute immunity for civil liability, because criminal liability is even more serious, it follows a fortiori that he's got immunity from criminal liability. And that's not a terrible argument, although, of course, the stakes are higher on both sides when you go from civil to criminal, so it's not clear why we're going that way. But what's remarkable about it is that, Fitzgerald is cited over and over again, almost as though it's like the entirety of the Constitution. So not only do the text of the Constitution, and especially the impeachment clause, and the original understanding disappear, but the other bookend from the Nixon administration, right, United States against Nixon, Nixon, right, also disappears, right? This is the Watergate tapes case, which stands for the proposition that the president isn't above the law as the dissenters hammer. And so there's a precedent here, but there are other precedents that are being just almost completely ignored. That's all I want to say about that for now.
Great. And let me build on that last observation. Nixon versus Fitzgerald is aggressive enough. I mean, it's made up in its own right, in the name of trying to liberate presidents to do their job. To the extent that the Constitution speaks about immunity at all, it does so in the context of temporary immunity while Congress is in session. And you could extend that speech and debate immunity from Article 1 to the executive branch, arguably. But that's ironically the argument that Bill Clinton made in Clinton versus Jones. Not that I want to be immune forever from anything that I do that's wrongful, but I just want to be free while I'm in the White House, not to be burdened by civil or, by extension, criminal litigation. And that argument lost in Clinton versus Jones. And that was the most plausible of the immunity arguments. I think a decent argument that's been made in the last several decades. And yet, so the court is making this stuff up and not even very carefully. Let me move from that to the next case I'll briefly mention. That's the Consumer Finance Protection Bureau versus Community Financial Services Association. The CFPB is a federal agency enacted or created in 2010 after the Great Recession and the financial markets meltdown in the Dodd-Frank law. And it created this new entity to basically oversee banks and other entities that interact with consumers in the finance realm to make sure that people weren't being taken advantage of. The CFPB is a hated entity by conservatives, and it's already been subject to several big lawsuits, including one that invalidated the independence enjoyed by the head of the CFPB from removal by the president except for good cause. That was the Seal of Law case a few years ago. That was under the Appointments Clause. This case, this term, was a challenge to the CFPB that was embraced by the Fifth Circuit under the Appropriations Clause, under the argument that the CFPB is improperly funded, so it cannot operate. I mention this in part because this 1-2 punch of appropriations and appointments is not that uncommon among conservative critics of federal activity. So that's exactly the combination we saw yesterday in Judge Aileen Cannon's dismissal of the Mar-a-Lago documents case. She ruled that Jack Smith was improperly appointed under the Appointments Clause, and then she also said, and I also think, but I'm not going to actually ground the decision on it, that Jack Smith is improperly funded under the Appropriations Clause. So these are two kind of hand-in-hand arguments that conservatives seem to be making against federal activities that they dislike. Happily, the court rejected the challenge under the Appropriations Clause, which was grounded in the fact that, unlike many other federal agencies, Congress doesn't appropriate money for the CFPB on an annual basis. Instead, Congress passed a law that said the Federal Reserve gets to give some of its money to the CFPB to cover the CFPB's needs. And this absence of an annual appropriation, the critics argued, gives the CFPB too much power and violates a separation of powers. The court rejected this 7-2 in an opinion by Justice Thomas. And I think that's an important fact, that he argued, he authored this repudiation of the Fifth Circuit in this case. Gorsuch and Alito dissented in a dissent that really is not that impressive from my point of view. Thomas relied extensively on the pre and post constitutional ratification practice by Congress of giving money to agencies in a much more flexible way than the critics argued was constitutionally required. So as to the duration of the appropriation and as to the amount of the appropriation, there were many early statutes that Congress enacted that gave the executive branch a lot of flexibility, and Thomas really relied on that. I think one of the most interesting things about this case, and I know that you blogged about it a little bit, was a separate concurrence by 4 of the 7 justices in the majority, led by Justice Kagan, that highlighted not just the history at the founding that demonstrated the flexibility that Congress had given to the executive branch in funding various activities, but how that flexibility continued all the way to present day. And it's, I think, in an era where history and tradition are invoked as these talismanic ideas, that the fact that the majority did not want to rely on post-ratification history and tradition was an interesting one. And how much and the way in which history and tradition plays into disputes not over individual rights, as in Dobbs or the Second Amendment, but in cases involving federalism and separation of powers. I think that's an interesting wrinkle on the history and tradition idea, and might explain part of why Thomas and Roberts and Ketanji Brown Jackson, for that matter, didn't join Kagan's invitation to add all of this more recent traditional material in there. I think one possibility is, to the extent that the founding history is clear, some justices think that subsequent history and tradition should not be allowed to overcut it, to overwhelm it, or to repudiate it. And to the extent that it's not clear, then maybe we would resort to post-enactment, post-ratification traditions. But once we know what the tradition was at the founding in these separation of powers realms, we're going to stick with that and that alone.
Yeah, because of time, I don't want to say anything further about that case. I agree that it was a somewhat expected result, but nonetheless welcome to see a non-ideological lineup. I do want to build on the history and tradition point, though, to talk about the next major case, which was United States against Rahimi. And this is a case that is a sequel to a case decided 2 years earlier, New York State Rifle and Pistol against Bruin. So just a little bit of background. Prior to 2008, the Supreme Court had never found that the Second Amendment conveys any individual right to possess or own firearms. Then in District of Columbia against Heller, the court announced that that's wrong, that there is an individual right to possess firearms in one's home. In 2010, in the McDonald case, the court extended that to say that this right is incorporated as against state and local laws, so that Chicago, no less than the federal government, was forbidden from too zealously regulating firearms. But there was a question that persisted from 2010 to 2022 about what the test was for determining whether a particular law regulating firearms was constitutional, because Justice Scalia, who wrote the Heller case, said, we're not saying that all firearms regulations are forbidden. Long-standing regulations, those involving sensitive places and so forth, those are going to be permissible. And during the 12 years between Heller and the Bruin case, the lower federal courts took a variety of positions, but I would say the dominant position was that they applied something like intermediate scrutiny, right, to laws regulating firearms. Why intermediate scrutiny? Well, not rational basis, which is the lowest level of scrutiny because it's a constitutional right. Why not strict scrutiny, the highest level? Well, Justice Thomas said that it should be, and had dissents from the denial of certiorari complaining that the court was treating the Second Amendment as a second-class right, but the courts that were applying intermediate scrutiny were recognizing that unlike words protected by the First Amendment, which after all are only words, the use of firearms carries extraordinary dangers, and so you want to have a test that isn't going to invalidate virtually everything. In the Bruin case, the court rejected that and said that the question of whether a regulation today of firearms is valid is whether it fits within the historical tradition of the regulation of firearms. Now, what's interesting, of course, is that the Bruin case involved a New York statute that was already over 100 years old. What's also interesting is that the court didn't really give an explanation for why history and tradition. One answer, right, is I think the one that Vic alluded to in discussing the Appropriations Clause case, which is you might think, well, you look to the history at the founding to see if you can fix the meaning, and if you can't, then you can look to tradition. This is sometimes associated with a term that James Madison uses in the Federalists. He says that a subsequent practice can liquidate the meaning of an unclear term. And so you might think that a tradition reflects a kind of liquidation insofar as the court in the Appropriations Clause case was rejecting subsequent history. You might think that they're rejecting liquidation entirely. But in any event, that was the test we had coming out of Bruin. Well, along comes the Fifth Circuit, and they've got before them this case of Rahimi, who is a very bad guy. He's a guy who had previously menaced his estranged partner with a weapon. He was charged with all sorts of firearms offenses, and he was subject to a domestic violence protection order under Texas law. There's a federal statute that says that if someone is subject to such an order, then they are not permitted to possess firearms. I'm simplifying somewhat, but that's the basic idea. And the Fifth Circuit said, well, there weren't domestic violence protective orders that resulted in disarmament at the time of the founding, and so this law is unconstitutional under the Bruin test. Supreme Court takes the case, and one justice, Justice Thomas, who authored Bruin, agrees with that. He says, yeah, that's right. There were some cases that were very loosely analogous, but nothing that imposed such a severe penalty and so sweeping and so forth. But 8 justices think that that's a bridge too far. And so this is an example of what, Vic, you were talking about earlier, where the court says something very broad, as in the immunity case, and then maybe has a chance to go back and clean it up. And so you can understand the Rahimi case, which 8-1 rejects this reading and says you don't have to find an exact analog. There were laws at the founding permitting the disarmament of dangerous people. That's basically what this is. And that is a way of reining in a certain kind of otherwise very rigid originalism that you see within academic debates about original meaning, so that there are people that we don't normally think of as originalists who will say, yeah, of course we care about what the original meaning was, but we care about it at a pretty broad level of generality. And so one way to read Rahimi, I think this is overreading it, but one way to read Rahimi is that the court realizes that at least in this area, this kind of originalism, the version that says, look to the exact practices of the founders, is going to lead to much too unpalatable results. I hope that's how they read it. I would urge them to do that in other areas as well, but we'll see how that gets interpreted in subsequent cases.
That was actually very helpful for me to think through it, Mike. Thanks for that. Let me add one other way in which I kind of think about Rahimi, and that is, this is the first case that the court has taken to decide the meaning of the Second Amendment, where the law in question was one that kind of had a lot of important real world implications, and that most people in America would say, hey, this people like this shouldn't have guns. So in Heller and in McDonald, DC and Chicago were the only 2 places really that prohibited possession of a handgun in your home for self-defense. Even in Bruin, the law that was struck down by in New York was one of only 6 or 7 such laws, and the opinion had a roadmap for how New York could rewrite its laws along the lines of the other 43 states, so as to preserve kind of the mainstream of what it was doing. This case, had the court affirmed the Fifth Circuit, would have been the first time the Second Amendment was really deployed in a way that strikes most of America as completely nonsensical. So in that sense, I think this may suggest the court is sensitive to the temperature of the nation when it comes to gun use, and that's even before this past weekend's tragic events. So how are we doing on time, Mike? I want to know before we go ahead here.
We've got about 12 minutes left. So
okay.
I could say a word about the bump stock case, but let's get on to Loper Bright.
Loper Bright's the one I'm talking about. So forget the context of Loper Bright. It involves kind of fishing boats. But the question in Loper Bright was whether the court should revisit and repudiate the so-called Chevron doctrine, which is an administrative law doctrine going back to the 1980s, involving a case in which Chevron was a party. It involved a Clean Air Act air pollution case. And the question is, when a statute is ambiguous, a statute that Congress writes is ambiguous about exactly what regulatory power an agency has as a matter of law, the agency that is being empowered by that statute is entitled to read the statute in a reasonable way and have its reasonable interpretation upheld, even if the court acting completely on a clean slate would have construed the statute differently. So the agency where the statute is ambiguous is given deference as to the very meaning of the statute, even if that reading is not the best reading in the sense that it's the reading the court would impose in the first instance. It still prevails as long as it's minimally reasonable. So when decided, Chevron was not a particularly partisan or controversial case, but it was a tool by which I think Republican administrations as in the Chevron case itself, would construe enactments by Democratic Congresses very narrowly so as to effectively deregulate whether or not that was the wish of Congress. Nowadays, the conservatives who used to like Chevron deference have been savage critics of the administrative state, and so Loper Bright was an opportunity for them to cut back on this deference that's been given to administrative agencies. And by a 6-3 partisan line vote, Chief Justice Roberts for the court overruled Chevron, said it doesn't square with the Administrative Procedure Act, which gives courts and not administrative agencies the power to interpret the law. It's important to understand that Chevron is not about whether to defer to an agency on a matter of policy or science or technology. It's about whether to defer to the agency on the interpretation of the meaning of the words of the statute. And Roberts says, look, that's a particularly distinctively judicial task. The Administrative Procedure Act doesn't suggest any deference. So Chevron was wrong when it was decided, and we're going to fix that mistake. Mike and I talked about this case a little bit at the end of last year's roundup as a preview. And one of the things I said is I've always been a critic of Chevron because I worry that administrative agencies will construe the statute and its authorization of regulatory power broadly. And if Congress didn't want that, it's hard for Congress to pass another law to override that administrative interpretation because, of course, the president gets to veto the reclamation bill. So the president gladly takes the power, reads the statute broadly in ways that he likes, and then when Congress says no, that wasn't our deal, Congress has to have 2/3 to reclaim power that it only needed a simple majority to give. So I thought there was a constitutional non-delegation kind of a problem with the Chevron doctrine. Here's what I don't like: the fact that there's hypocrisy here because the conservatives that used to like Chevron don't like it now that we have Democrats winning the White House, and those agencies that are being deferred to might be more pro-regulation than anti-regulation. But let me explain briefly why I don't think Chevron is all that momentous. First of all, as the court pointed out, it hasn't really been relied on by the court very much in recent years anyway. Hadn't been cited very much. This case, Loper Bright, is more about sending the message to lower courts, not about how much the Supreme Court really was applying Chevron anyway. Second, there were already lots of ways to get around Chevron. If the question was so-called a major question, then Chevron wouldn't apply. If the statute wasn't ambiguous in the first place, then Chevron wouldn't apply. So willful judges who wanted to override what agencies were doing could have found ways to do it, even though Chevron deference is still on the books. That's the nature of a deference doctrine. It's just very hard to enforce against judges who don't want to take it seriously. Third, Roberts makes clear that all the other cases that have relied on Chevron thus far remain intact. We're not going to overrule the results of all those cases. And fourth and finally, Roberts also suggests that if Congress wants to reinstitute Chevron in the context of a particular statute by explicitly conferring interpretive power on the agency and telling a court to defer to the agency's interpretation of the statute, then that's constitutionally permissible up to the boundary of the non-delegation doctrine, whatever that might be. So I would say this is a significant case, but not perhaps as much of a landmark case as some people might otherwise believe.
So let me say a couple things about that. So I basically agree. I was less unsympathetic to Chevron for the previous period. I do think that the decision will have important consequences in the lower courts, because although it's true that the Supreme Court hadn't relied on Chevron in many years, the lower courts routinely do so. And this is kind of a shot across the bow telling them, don't do that. You've got to actually parse the statute pretty carefully. Second thing I want to say is that it's a question I raised on my blog after the case was decided. It's not clear whether Congress could reverse this wholesale, right? So that is, imagine a statute as an amendment to the Dictionary Act, for example, that said, when a term is unclear or ambiguous or there's a statutory gap and the statute is subject to administrative implementation, the agency shall be given deference. There you might say, well, if you can do it retail, you can do it wholesale, except that the opinion relies on this notion, the quotation from Marbury against Madison, that it's emphatically the province and duty of the judicial branch to say what the law is. Well, that suggests a kind of constitutional separation of powers underpinning, which leads me to think that maybe Congress couldn't reverse it. We probably won't find out because, the bills that have involved Chevron that have been introduced in recent Congresses have all been aimed at doing what the court just did in Loper Bright. I don't think there is the momentum. It wouldn't be until perhaps a, Democratic administration on the scale of, FDR's victory to do that. Okay. I want to just briefly mention two other administrative agency cases, and then maybe we'll take a question if we've got some time. So the court also decided two other cases in which it ruled for the plaintiffs who were challenging the administrative agencies. So one of them is a case called Corner Post, which was decided the very last day of the term. It came out kind of as a teaser or an appetizer before the Trump immunity case. And in it, the court had addressed the question whether the 6-year statute of limitations for challenging an agency regulation begins to run when the regulation is finalized or when it first applies in some adverse way to the potential plaintiff. Now, you might say, gee, a statute of limitations case, that's really, really boring, except that the answer the court gave, I think, licenses all sorts of litigation challenging administrative agencies. And it's useful, I think, to compare this case with the case of the mifepristone case. So let me give the background for that. So remember, in the mifepristone case, mifepristone, known as the abortion pill, was approved by the FDA 20-some-odd years ago. It was later, they made some amendments to make it easier to prescribe. During the pandemic, the FDA allowed for its prescription without an in-person visit to a doctor. And the Fifth Circuit, the federal district judge, very conservative federal district judge, struck down all of that. The Fifth Circuit partially reversed that, left in place the striking down of the more recent actions by the FDA, but reversed the part of it that struck down the original approval of mifepristone. Now, the Supreme Court eventually finds that there's no standing, but I want to focus on what the Fifth Circuit did. In saying that it was essentially too late to challenge that regulatory approval, the court, I think, made a reasonable conclusion that you get a certain amount of time to challenge a regulation. After that, there's reliance on it, all the sort of reasons we have for not having challenges way late. By saying in the Corner Post case, as it did, that the 6 years start to run after the regulation first applies to a particular plaintiff, the court is effectively allowing challenges to regulations many, many, many years after the promulgation of the regulation in ways that even the Fifth Circuit was uncomfortable with in the mifepristone case. So I think that is a kind of sleeper case, and it provides an opportunity for additional challenges to administrative agencies. Final case I mentioned just very, very briefly is the Jarkissi case, which basically says that where there is an 18th century analog to what an agency is doing, and the agency has enforcement authority in the courts, you got to get a jury trial, and that's another limitation on what agencies can do. I don't want to get into the details because they're kind of complicated, but it's basically a fraud case in which the agency had a choice of proceeding within the agency or out in the courts, and the court said you got to go to the courts. All of this, I think, combines to paint a picture of a court that is sort of rebelling against the administrative state. And, if Trump wins the election and we have a Republican administration, that might not make that much of a difference because, mostly Republican administrations don't try to do that much, right? Their view is they want to deregulate, but it could be a big deal the next time there's a Democratic administration.
So let me jump on that, Mike, before you turn to a question. Indeed, if Trump wins, then, maybe some of the hostility to the, administrative reinterpretation of statutes in particular directions, that might dissipate, that might fade as these things go. Just one other thing about the Jarkissi case, a couple things. So the court decided that the Fifth Circuit was right on the Seventh Amendment issue, and they actually cited a piece that I wrote, so I can't disagree with them there. But the Fifth Circuit had invalidated the SEC's actions on other grounds as well, including an appointment clause issue and also a non-delegation issue. And interestingly, I'm not sure what the Fifth Circuit does on remand or when the case is below, because those parts of the Fifth Circuit's opinion were not touched by the U.S. Supreme Court. They were not repudiated, but neither were they affirmed. And those cut more broadly in eroding SEC authority. So I don't know what's left of those claims after this Jarkissi case is narrowly focused on the Seventh Amendment.
Great. We've got a question about what Rahimi and some other case say about future gun control legislation and litigation. And I want to say one thing about that. I'm going to try to answer that in a sort of backwards way. The one case that we didn't talk about that I think is worth mentioning here is Garland against Cargill. So this is the bump stocks case. So you may recall that after the mass shooting in Las Vegas a number of years ago, the President Trump's administration issued a regulation that effectively banned bump stocks. Bump stocks are a device that you attach to a semi-automatic rifle so that the recoil of the rifle bounces off your shoulder and essentially makes the trigger go so fast, or your finger on the trigger go so fast, that it effectively converts a semi-automatic weapon into an automatic weapon. And we've had a long-standing machine gun ban that everybody has long assumed is valid. And so the question in this case was whether that regulation fell within the statute. And the court, somewhat surprisingly to me, because after all, this is something that even President Trump was willing to do, said no, relying on a very technical reading of the language of the statute, referring to the action of the trigger, saying, well, the bump stock doesn't alter anything about the gun. It only alters how the gun is used by the user. And there are diagrams in there that are taken from an amicus brief, and it's all very, very technical. And Justice Alito, who joins the majority opinion, even writes a concurrence saying, look, I know this is ridiculous. Like, there's no good reason why Congress would want to ban fully automatic weapons, but not semi-automatic weapons that are de facto fully automatic weapons because of this language. But that's the language we're stuck with. And I found the case somewhat perplexing, given that in Rahimi, they seem to be acting reasonably. Now, maybe the answer is, well, here they're saying, but Congress can always fix it if we do it under the Constitution. It's a little different. But, here's an action by a Republican administration, and they were unwilling to uphold it. As far as future legislation goes, I think that following Rahimi, states might be a little bit more aggressive than they would have been just in light of Bruin. I don't know if you have any thoughts on that, Vic.
Yeah, just quick, again, the question in the bump stocks case is that a gun case or is that a statutory construction case? Is that an administrative agency? How much leeway are we going to give the executive branch to interpret and extend a statute? So we don't know yet, but it could easily be more about not conferring power on administrations, Republican as well as Democrat, to go beyond kind of technical, albeit not that thought through text that Congress enacts.
Yeah, I think that's fair. I've got a question here about Loper-Bright. So a questioner asks, I read Loper-Bright, I read it and saw it as a reaffirmation of the power of the courts to interpret statutes. Is there any limitation on its application to state rules, et cetera, given that the case relied on Marbury against Madison? You want to take that, Vic? Sure.
I don't think it says a lot about, in particular, about federal judicial review of state. Are we talking about state agency actions? Is that what we mean with state rules?
I think that's what the questioner means. Yeah.
So this case was really focused on the Administrative Procedure Act. Mike is right that it invoked Marbury in a soft constitutional way, but it didn't invoke the kind of separation of powers concerns full-throatedly that I had written about why I didn't like Chevron. And that, I think, really would have made it impossible for Congress to reinstate Chevron wholesale and rather just perhaps retail. I think the question Mike raised earlier about wholesale versus retail is an open question because of the court's emphasis on the Administrative Procedure Act. But that emphasis on the Federal Administrative Procedure Act means that I don't think it really has anything to do with federal review of state actions.
Yeah, I agree with that. And just as an interesting background, right, the federal doctrine of separation of powers doesn't apply to the states. So state courts do things in ways that interact with state executive branch agencies and so forth that it would be impermissible at the federal level. Okay, there are some more questions, but I think we want to wrap up. So if you have a closing statement you want to make, Vic, or do you want to just end it there?
I'm happy to end it there. I want to urge people to read Judge Cannon's opinion yesterday dismissing another one of the significant cases involving President Trump, because obviously that matters a great deal in the next few months. I think it's quite ill-reasoned, and I worry about, and maybe we should do another webinar on this sometime, Mike. You and I have talked a little bit about this, but I really am troubled by the fact that you can find academics now to kind of support the zaniest theories in a way that I just don't think was true when you and I were in law school. I think there was more of a mainstream, and the academy has not kind of been kind of subject to the same kind of pull as society at large, but I think there's a problem there, and so Cannon is citing Steve Calabrese and Gary Lawson and others who have done a lot of great work, but also are saying some things that are really out to lunch now on some of these hot button issues.
Yeah, I'll just say one last thing and thank the audience for your indulgence, and thank Vic for a wonderful conversation, and Justia for putting this on, which is, there's been some writing recently in popular outlets comparing the Roberts Court now to the Warren Court of the 50s and 60s, suggesting that the reaction that, center-left to liberal law professors like you and I are having to this court, to the reaction of conservative professors to the Warren Court in an earlier time. And I just want to say, well, I think there are some similarities, right? The Warren Court was fairly loose in its commitment to text and history and so forth. One overwhelming difference is that the Warren Court, while certainly implementing values and having a certain political sense, was not dividing on partisan lines. That is, Earl Warren and William Brennan were both Republican appointees. They're the most liberal members of the court. They were often getting pushback on various matters from Felix Frankfurter and Hugo Black, or Democratic appointees, or to the right of them on many issues. There's shifting alliances. And so I think we are looking at a court that, rightly or wrongly, at least looks quite partisan and not just having values and politics.
And, it's not just the Warren Court, but even, the justice for whom you worked, Anthony Kennedy, the justice for whom I worked, Harry Blackmun, they were Republican appointees, and yet they're associated with very liberal rulings. I think this takes you back to your earlier observation about Justice Barrett, and the voice that may be emerging for her is important. I think in that regard, Justice Jackson sometimes joins the conservative justices because she's more of a progressive originalist, but she embraces that methodology. I go back to where I started. It's unfortunate that we had this last case, the immunity case, that broke down on close to near partisan grounds, because I think it does mask some of the consensus in the standing cases, mifepristone, the Idaho case, the digging of the Idaho case, CFPB case authored by Thomas, the court upholding we didn't talk about it, but the federal tax in Moore versus United States. So again, we shouldn't overweight certain cases, even though they're the ones that get all the press and that we care about. But definitely I hear what you're saying. I finally want to just thank Justia and also all the participants for for joining us today, especially since I had to be outside my office and it may have been hard to hear me at times, and I apologize for that. I appreciate the indulgence.
Thanks, everybody.
Yeah, thank you so much for all of your insights, Mike and Vic, and for joining us today. And thank you to our audience, as they said, for submitting your questions and joining us today. In the spirit of staying up to date with all of the latest developments in the court, we also wanted to remind you, as we did at the top of the presentation, of a great resource available for Justia Connect members, the Justia Daily Opinion Summaries. As a reminder, you can receive case updates directly to your inbox for the jurisdictions and practice areas of your choosing to keep you in the loop. If you'd like to sign up for that for free, you can go to newsletters.justia.com. Thank you all again for joining. Have a wonderful rest of your day.